Okay, hello everyone and good morning. Thank you so much for joining us for today's free webinar, Is Your Business at Risk? 10 Tips to Manage Risk and Maximize Value with Mary Jutin from TrackLight. My name is Erica Malsberg and I'm the Chief Marketing Officer for Early Growth Financial Services, and I'm going to be your moderator today. So this presentation is going to run about 40 minutes. If you have any questions as we go along, please feel free to just jump right in with them. Don't just raise your hand. You can actually enter them in the question field, or you can also tweet them to us at Early Growth FS with the hashtag Startup Risks, and we will answer them as they come, or we'll also save some time at the end for a Q&A to address additional questions. And if we do run out of time, we will provide contact information at the end of the presentation, so you can feel free to follow up with us individually after the presentation. And we'll also be sending out a follow-up email tomorrow that will have a link to the deck and the recording, so you'll have that for your reference. So before we jump in, we have a lot of content to go through today. This is a really wonderful presentation we have here from Mary. So before we jump in, though, just a few quick words about Early Growth Financial Services. So we are an outsourced financial services firm that provides accounting, strategic finance, CFO services, tax, and valuation services and support to small to mid-sized companies at all stages of the development process. And we're currently operating in 9 markets from Silicon Valley to New York City. And we have about 475 active clients, including TechShop, Indiegogo, Ouya, Zendesk, Clout, RocketSpace, OpenERP, and so many more exciting companies. If you're interested in learning more about us or signing up for a free 30-minute financial consultation, you can just go to our website. Okay, with that out of the way, let's get to the real show here. It's my honor to introduce to you today Mary Jutin. And so Mary, founder and CEO of TrackLight, has dedicated her more than 25-year career to helping businesses achieve and protect their success. Specializing in leading companies in transition or startup phases and helping them create sustainable operational and financial growth, Mary wants entrepreneurs and businesses to have Fortune 500 style software solutions. Using her extensive education, including Bachelor of Commerce degree from McGill and a Juris Doctorate from Arizona State, as well as her U.S. and Canadian accounting and public accountant certifications, Mary created the only self-guided software platform that creates your custom intellectual property IP strategy. Mary's an international writer, speaker, and mentor, and co-chairs the Arizona Technology Council's Law and Technology Committee. She previously represented entrepreneurs on the board of the Crowdfunding Investment Regulatory Advocates and is currently on the Emerging Enterprise Committee of the Licensing Executive Society. So good morning and welcome to you, Mary.
Thank you, Erica. Thank you for having me today.
Of course, we're very excited to go through this. You know, business risk isn't always the most sexy topic, but it's essential, and you cover a lot of really important ways that people can protect their companies. So I'm going to just hand it off to you and take it away.
Okay, thanks, Erica. And as Erica mentioned, please, I can't see the questions, but Erica will interrupt me and pass on questions as we go through it. And it always makes for a better presentation if people ask their questions, you know, when it's top of mind, and I'm happy to stop talking to do that. So I am an entrepreneur myself, and this is, you know, my take on what our business world looks like every day. And as you're starting your company or growing your company, there are so many different competing daily tasks that often what happens, and I know I'm guilty of this, is that you jump to the thing that you want to do that's the most fun or the path of least resistance. And unfortunately, these 10 topics here are not, as Erica pointed out, they're not sexy topics. Unfortunately, if you don't have these nailed down, this is an area where you could, you know, it can come back to bite you later, and we certainly don't want that to happen. So as we mentioned, you can just ask questions throughout. So we're going to just dive right in, and some of this may seem obvious, but we've worked with hundreds, if not at least 1,000 entrepreneurs at this point as we, you know, over the last 5 years. And you'd be amazed how many people say to themselves, oh, I will just do that LLC a little bit later, or I'll wait until I get some customers before I do it. So the biggest, you know, you're putting your personal assets on the line if you don't incorporate in some fashion, whether that's a C Corp, an S Corp, an LLC. There's some other fun fun type of entity formation that can be done around B Corps, et cetera. And I will leave that to the early growth financial folks. That's who can help you with that. But one of the first things that you need to do is limit your personal liability. Okay, so as my bio indicates, I have a little bit of an intellectual property obsession. When I went to law school, I noticed how many founders were making mistakes from the very start, even before they would ever go to an attorney or think of going to an attorney. They were making these mistakes that were then causing them extreme pain, and by extreme pain I mean losing time to market and losing a lot of money having to redo things. So that's what I'm going to talk about a little bit. Some of these have intellectual property, you know, intellectual property influence, but a lot of them are things that you do that you wouldn't think impacts your intellectual property. So very brief overview of what is intellectual property. And if you have co-inventors, this is really, really super important. So you often hear about people saying, oh, I'm going to patent this, patent that. So a patent is basically either you're protecting, you're looked to protect your idea that has some sort of useful application, like an invention. So that would be a utility patent, or you've got some really unique design, like the Coca-Cola bottle, and you're looking to protect that. So a patent is the right to stop other people from basically manufacturing or making something. So using this pen here as an example, if the click piece at the end is your invention, all that does for you is allow you, once you have a patent, to stop other people from doing the clicking part. So the challenge for an early growth company, early stage company, is that patent litigation is some of the most expensive litigation on the face of the earth. So you don't want to get all diverted into trying to protect your patent. And, you know, if you look, there's not only trying to protect yourself against people infringing, there's the whole patent trolls. So this is an area where you have to make sure that you have some legal help. You don't want to go this alone at all. But as far as this webinar, what we're trying to get at is what a patent is not, because there's a lot of confusion. And you get people getting together and they are saying, okay, we're co-inventors, we're going to protect our intellectual property, we're going to get a patent, and we're going to go from there. But they don't understand that they might actually be looking for something as simple as a copyright, which protects others, stops others from using whatever you've created without your permission. So that's completely different from a patent. A patent is not, you can't get a patent on music, you can't get a patent on pictures and those type of things. And a patent is not a trademark. This is a little example of potential trademark infringement. Trademark is basically what you get if you want to protect your brand. So that's the ability for you to use a name exclusively, because that name means that the public is going to get your brand when they buy the product. So for example, here it's Dumb Starbucks, which didn't guarantee the consumers that they were actually going to get Starbucks coffee. And why do we care about this, multiple inventors and talking about this? I talk, yes, there is a specific, the way the patent system is set up. If I invent something with Erica and we go to file for a patent and we just file it in both of our names, because that's how you have to start. You have to file in with people, not companies. If we file it in our own names and then we don't assign it to the entity that you formed before you file for your patent, if we leave it as just both of us, Erica can go off and independently sell that. She could sell a worldwide exclusive license to use that pen clicking to one pen company in the world, and I wouldn't have anything to do with it. And I would then not be able to do anything in terms after Erica. I couldn't then sell the pen clicker to anyone else in the world. So you can't just ignore the fact you have multiple inventors, you have to deal with it. So the first tip, again, you get your entity. The second tip is when you have multiple inventors or co-inventors, make sure that you are assigning your patents to that entity that you've formed, because in that way, that's where the patent lives, and the decisions have to be made together. And just as a note, we often get questions around this. The US system did change as far as inventions. It used to be whoever filed first. It used to be whoever invented first, and if somebody filed, you could go back and show dates and everything, and you could contest a patent. The change that was made in the US is that it's now first inventor to file. So it doesn't mean if you just heard my idea standing in line at Starbucks, you can't just go and take my idea, run off and file a patent, because I could prove that I was the actual inventor of the idea. So co-founders. This is the happy, this is the before, and this is unfortunately what happens a lot when you have co-founders, and that comes from personal experience. However, the co-founders, co-inventors are linked, because if you have your idea, if you're getting patents, trademarks, copyrights, you're protecting all your valuable intellectual property, which often is at least 80% of the value of your company, you need to make sure that the co-founders have an agreement. And this is something that is linked, because if you've assigned, let's say Eric and I assign our patent to our new LLC that we've created, then as co-founders, we have to have an agreement, and whether that's in the LLC operating agreement or a separate co-founders agreement, you need to have agreements that talk about what happens when Eric and I don't get along. And if you don't believe that happens, then you need to look at some of the writings that are out there around the co-founder disputes that happen, because they happen daily. So when Eric and I don't get along, there would be something, it's a really important provision, it's called a buy-sell provision, which would allow us to basically get a business divorce. So you don't want to leave anything to handshakes. And this whole notion that you just, I love the popular show Silicon Valley. I'm a big follower. I've written in Forbes about all the IP mistakes that they've made, and I was probably the only person in America who was super excited to see that they have IP litigation now going on.
That's great.
So that makes me super, super nerdy. But it is at the root of that is the subject that we're going to talk about next, which is like this employee versus contractor, and who were you working for when you started or came up with your idea. Because it gets back many times to who owns the IP. So how you can put your company at risk is, and I'll use the Silicon Valley example, is Richard, who's the main character, he came up with the idea for his company. He was still working, excuse me, at Hooli, which is the fictitious company there. He was still working for somebody else. Now, the tests are, if you're an employee of another company, you have to make sure that you go and read your employment agreement. You need to make sure that there's nothing in there that says, hey, if I invent something at Hooli, Hooli owns it. And Motorola used to be like that, where if you signed your employment contract, it said whatever you think of, whatever idea you come up with, whether it's in Motorola's space that they operate or not, they own it. So if you are working on your company on the side, you need to read your employee agreement, and that is at the crux of the lawsuit that's now going on the Silicon Valley show. And we've just talked a little bit about the assignment of the IP rights. So, both Eric and I would have to make sure that when we came up with our great idea, that I would look at my agreement with TrackLight, Erica would look at her agreement with Early Growth Financial Services, say, oh yeah, this is fine, and don't wait until after you're a success to do this, because generally then the company will try to find a way to claw back. And the other one note here is that when you are patenting or otherwise getting any kind of IP protection inside the US, it is only for the US. And if you're doing something like a crowdfunding campaign, you are operating where you're putting it out there to the world. So make sure that you understand exactly who you're talking to. And if you're going international, there's different steps that you need to take before you put yourself out there, your invention out there. Okay, and a little bit of information on software work for hire. This is an area where people don't understand that if just because you pay for something, it does not mean that you own it. So there's a woman that I won't name here in Phoenix where I'm located, and she paid somebody to develop custom software. She didn't read the contract appropriately, and in there it entitled her to have the code, but she didn't get the source code. She couldn't make any modifications. She had to pay a whole extra, and it was, you know, a 5-figure amount, a whole extra amount to actually get ownership of the software. So work for hire means you're using contractors, and if you're using a contractor, you need to read or hire your lawyer to read that agreement to make sure that you get full rights to the ownership of what's being created for you. The default for a lot of creative people, because this is their livelihood, the default will be when they give you a contract that they will retain some of the copyright rights, and that you may end up paying them a licensing fee to use your own logo that they've developed, or you may have to pay every time you're using a photo. So it's really important that you try to negotiate the best deal for you. So here's another thing. The idea of copyright is that you have to get the proper permission. When you go out on the internet and you're doing a blog, or you're doing you know, an article, you're using video, whatever, like these pictures that we have here are all from either Creative Commons or any of the free websites, and you'll see in some of these slides there's little attributions at the bottom. It's really important to do that, because there's all kinds of software now that actually crawls the internet and will report back to people when pictures are being used without the proper attribution. And the fines that you get are not insignificant. I mean, you can get a $5,000 fine from Google, and you just don't want that. We have examples of folks who did crowdfunding campaigns where, you know, if any of you have done that, so much work goes into your campaign, then you put it up on Indiegogo or Kickstarter, and you know, you've just borrowed some videos, or more frequently, you've borrowed some music. There are sites where you can get specific free music that all you have to do, again, is give the attribution. So just say copyright or used with permission by, and you avoid a fine. And to put all that work in and then have to pay a $5,000 fine is not great. So just we have on the Tracklite website under resources, it's going to be split into external resources this week, but right now it's just under resources. We have a list of places where you can go for free photos, music, and videos that you don't have to pay for, and if you do the attribution correctly, you won't get a fine for. Okay, so I want to talk a little bit, oh, and sorry, I meant to say one more thing just on number 4. Early Growth Financial can help you with the whole distinction between employees versus contractors. And that's a legal distinction, and you should really be careful with interns. Sorry, I meant to go back. You should be very careful with interns. It's different. Employment law, of course, is state by state. but making sure that you aren't hiring people and pretending that they're contractors when they're really employees, because that can get you in trouble with your state unemployment office. And then also interns, most states, I know in Arizona, we can't just hire interns and not pay them. So that's something that the folks at Early Growth Financial Services can definitely help you out with.
And I'm going to just jump in real quick before you move on to number 5 here, to say, yeah, it's a fraught topic, the whole employee versus contractor versus intern. And we've done webinars with some lawyers on, focusing exactly on those topics. So if you're interested or worried about that, feel free to check out our YouTube channel or our SlideShare channel, and you'll be able to see some previous content on that might be useful. Also, why don't I just, while we're taking a break, I have a few questions lined up here,
Cool.
Mary, so why don't we just do a few of those as we're kind of halfway through, or a little under half. First of all, someone asked where they could get some free resources for pictures and music and stuff. So that's great that you guys have external resources right on your site. So I strongly recommend everyone check that out. It's, to have good images and music that you can use without putting yourself at risk. I'm going to be checking that out. That's great. Okay, so we, first of all, Simon wanted to know, can you get a patent on code? Okay.
So the software patent, the Supreme Court has made that a bit of a muddled area. And so it used to be that you could get patents on what was called business methods that you are creating software for. So the answer is it depends what the software is for. And that is something where you want to go talk to an attorney. The other ways of protecting your software can be copyright. That is not a simple process. There's, you want to make sure you're not going to reveal your trade secrets in your code. And that is often what people do now with software is they may file a provisional patent on it just to sort of have a line in the sand, but then it's not something where you then share it with everyone. You want to make sure you're trying to keep it also as a trade secret. And we, again, if Simon wants to send me a note, I can hook you up with some attorneys who specialize in software patents.
Okay, wonderful, thank you. A couple more questions before we move on. Chen wanted to know, does it matter what entity you choose prior to filing for a patent, or are all entities created equal for that concern?
For a patent, all entities are created equal. And so it doesn't matter if it's an LLC or a C Corp because you can just reassign afterwards.
Okay. All right, great. And then the last question here from Sharon, you mentioned, having a co-founder agreement in writing. Is there somewhere where there's an online template, or would you recommend using an online template for a co-founders agreement?
So great question. There are some free forms, and again, it's on our site, and it's Orrick. It's a law firm called Orrick, which is ORRICK, and I think it's under startups. It's also under business lawyers, and then we have a capital and formation. We tend to put the resources in multiple places on our site so that it's more intuitive. They have some online forms, but this is going to be my caveat for all online forms, is that at your own peril, just go grab it and use it. What I always suggest is, look at something like Orrick as a starting point, and then always have a professional look at it, because the simplest things can kill a deal further down the line. And I can tell you from personal experience, one of my former co-founders was a paralegal who I went to law school with. He became a lawyer. We did our own LLC operating agreement, and we had to throw it all away and start again. Not his fault at all. It's just, that wasn't an area that we had spent a lot of time practicing in, obviously. So.
Yeah. Okay, great. And also to you, Sharon, we posted on our blog recently a post about this topic as well that has a link to a co-founders agreement. So you can check out that one as well, but at your own risk, basically. But it's a good starting point, right, to look at. Okay, with that, keep the questions coming, folks. And Mary, let's move on to point number 5, disclosure here.
Okay, so this is one where, and it's kind of the last one that's specifically on IP uh, in terms of protection. So I mentioned briefly that people go out and they do a crowdfunding campaign. So what I'm going to tell you applies for any kind of public disclosure, but I like to use crowdfunding because people don't think of it as anything, it's not a big deal. But other examples are you go to a trade show, you pitch investors, and they're not all accredited investors, so they're not agreeing to sort of keep it behind the walls of a non-disclosure or to keep it secret. So an enabling public disclosure has to be all three. So disclosure is pretty clear. It means you're telling somebody something. Public means anything on the internet automatically qualifies. And then enabling is that, let's say I came up with, I'm going to go back to my pen, I came up with the clicker. So if I was to go to a trade show or I'm doing a Kickstarter campaign on this, Kickstarter specifically requires that you show how your product works. So enabling public disclosure means if somebody looked at it who works in the pen industry and they could replicate what I'm doing based on what I'm showing, then that becomes an enabling public disclosure. So the key is to make sure that you have your patent before you do that. So, or your provisional patent filed before you do that. It's particularly important if you are doing crowdfunding, because once you're on the internet is public disclosure, and it's international public disclosure. So you don't want to start that clock ticking. There is like a 1-year grace period only in the US. If you do make an enabling public disclosure, then you can go off and get a patent. But what we hear a lot about is somebody will see somebody's idea, they know they can't run out and patent that, but then they make a few tweaks to it and then they go patent it. So just make sure that you get your ducks in a row and do that. Do any provisional patents or patenting that you want to do it before you put it out there for the world. So fundraising, I talked a little bit about that because what I just talked about for enabling public disclosure also applies. Now, some of you may know that there are these new rules that allow you to do public solicitation of funds, and that's still taking money from non-accredited investors. There's some new rules that are going to come out in June that change that a little bit, but you just really need to be careful. So when you're fundraising, you need to basically don't start with your pitch or your business plan and everything and start going out there. You do need to seek legal advice for not only your intellectual property, but for your for making sure that your pitch and your business plan, and I'm going to talk about financial projections briefly, but that's more of an early growth financial services area. You have to make sure all of those are vetted before you put them out there. And the solicitation piece can be tricky because a lot of you can put your whole business at risk by running out and saying, oh, I'm going to use this new exemption, and then you don't realize that that means you can't raise money some other ways. So again, I have a law degree. I'm not a practicing attorney, and as the disclaimer said on the front slide, this is not legal advice, but we're trying to get you to put up your hand and seek professional advice before you start putting yourself out there publicly. And this is something that you can work with. There's many really cool new platforms like Flash Funders. There's obviously the older AngelList and Gust who are established. So it's just making sure that you understand when you go to a platform like that, is this going to be public, or are they only letting accredited investors in here? And I shouldn't have used the term accredited investors without defining it. So an accredited investor are people that meet certain income or net worth thresholds. And so if they're accredited investors, then you can present to them as long as you know they're accredited investors, and it's not considered public solicitation of funds. If you if you don't know they're accredited and you're out there using Twitter or Facebook to raise money, then you're basically putting yourself into this realm of public solicitation, and you can't use some of the other exemptions that go along with accredited investors. So if it sounds confusing, it is. And so it's an area where I've actually personally seen some people mess this up since the new rules came out last September on being able to publicly solicit funds. So, whether you're with an incubator, an accelerator, or a law firm, make sure you're getting that right advice. I mentioned this already. The big part of your value is in your IP, so it's really important that you are identifying it up front. And this is, basically what I was saying is we have this tagline, practice safe crowdfunding, which we do have a trademark on, which tells you that basically identifying and protecting your IP is very important before you pick your platform or decide how you're going to raise your money. So that's the point I wanted to make. There are just I don't even know, I think it's over 1,000 different platforms now, different ways of raising money using crowdfunding. The Jobs Act crowdfunding that we often hear about, which is referred to as Title III crowdfunding, that's still not, the rules still haven't been released by the SEC. There's going to be new, what's called Reg A plus crowdfunding, which will allow companies to raise money. It's basically like going public, up to, I believe, $50 million. It's not going to be attractive for very early stage companies because it's not that Jobs Act crowdfunding Title III that you hear everyone talking about. But in the meantime, there's, I believe now, 14 different states. Georgia is on this slide as the first state where there's crowdfunding within the state for smaller emerging growth companies to raise up to, in most cases, up to $1 million. And that's because the federal rules were taking so long that the states started doing this. So you can check with your state. You can go to cfira.org, which is an organization I used to be on the board of. I'm still a member. It's a crowdfunding intermediary regulatory advocates, or CIFRA, the world's worst acronym. So they have lots of information there. There was a recent article done by an attorney that shows you all the different states that have the crowdfunding, and they also break down the different crowdfunding. Prosper and some of these other lending clubs, these are great ways of raising micro amounts of money in addition to the traditional SBA loan.
Mary, can you just repeat that website again? Someone's asking.
CIFRA. So it's cfira.org.
Okay, great. And then Jan has a question. He's asking, how can you be sure that you're dealing with accredited investors? If you go through through CIFRA or something, is that then you're confirmed that they're all accredited, or?
Okay, so CIFRA is just an organization that has been working and lobbying and advocating for the crowdfunding that is, as we call it, equity or securities crowdfunding, which is at Title III. The platforms themselves will take on the responsibility for figuring out if somebody is accredited. So for example, I'm just going to go back in the slide, something like microventures. I refer to these as kind of like matching platforms, like Match.com for entrepreneurs and investors. And so what happens is microventures, if you go and apply to be part of their group and you're putting your information in there, they're taking care of making sure the investors are accredited. If you apply to a legitimate angel group, then they're going to take care of making sure that the investors are accredited. It's when you start doing this public solicitation that then it falls upon you to make sure that the investors are accredited. And so your attorneys can help you with that. There's investor questionnaires, and it's really important that you personally, I haven't used the public solicitation of funds because I like to keep it until there's any kind of federal federal crowdfunding option where you can attract non-accredited, and it's going to be on a platform where somebody else is going to take care of making sure that those people are meeting the tests. Because even once you can take money from people who aren't accredited, there's maximums that those people can contribute, like up to, like I think it's 20%, but don't quote me on that part. I just said that like 20%
Right.
of my income. So if I make $100,000 a year, then I can invest up to 20,000. As an entrepreneur, you don't want to be the one that's going to worry about that. So
Right.
that's kind of a long answer, but you just have to still be really careful, because there are a lot of people out there. As you raise money, there are people who will want to raise money for you, and they'll be like, you want to make sure they're a broker dealer, they're working, like these platforms that are up like Micro Ventures, they have broker dealer licenses. So then they're accountable to FINRA, which is the organization in the US that oversees the brokers. So you want to make sure that you're dealing with legitimate people, because if you really want to put your business at risk, then use some of these people who are, pretending to be brokers, and then they're going to charge you success fees and stuff, and you can get in a lot of trouble now. The SEC is cracking down on that. So that's the idea behind crowdfunding. It's supposed to make it more capital for entrepreneurs, more accessible, and allowing the average American to participate. So they refer to it as democratizing finance. But other than the Reg A, there isn't, and if you have crowdfunding in your state, there isn't the federal way of raising up to $1 million yet.
Okay, that's useful.
So,
Thank you. Great.
yeah. So just really quickly, number 7 is books and records, and just you have to file with all of these entities. And I know as a business owner, my background is accounting. I hate doing all of this, and that's why you should hire someone to, hire people to do these things so that you can run your business. And putting your head in the sand about books and records, filing, and all of that, that will just not end well. So it sounds obvious, but you would be surprised how many people ignore their keeping good books. And you have to be ready for when you go to raise money, you go to a bank, you report to your own investors. You have to have this. So a lot of this I've already talked about. Having an IP strategy is super important because it's 80% of your value. And it's also not just offensive, like making sure you're protecting everything. You need to make sure that you don't accidentally infringe on somebody else's IP. And ultimately, if you own all your IP outright, you'll be able to get a better valuation, and you'll be able to make more money. You can leverage and license your IP. You can't do that if you don't own it. So these are just a couple of stats here. $300 billion a year is quite significant. And I've already talked a little bit about trade secrets. This is a relatively inexpensive way of protecting your IP, but the key is it gets back to those really good agreements, whether it's co-founders, employees, contractors. You have to make sure that you protect your trade secrets. So again, no handshake deals. Don't tell people your secret sauce on a handshake. If you're going to talk to a potential large strategic partner, or you're going to talk to a supplier, make sure that you are getting in writing that they're going to keep your secret sauce secret. Because unfortunately, once the trade secret's out there, that's it, it's over. So just a couple of missteps. I think hopefully by now that everyone believes that intellectual property is not just for tech startups. Every business has something, even if it's just a name and a tagline and a website. You don't even if you don't have a website, you still might have a business name. I would put that forward that you do. When you're out there on the internet, if you're out and about and you see someone else's picture or hear someone's music, just because you don't see the C doesn't mean that it's not copyrighted. So the way to think about it is, if you saw a bike sitting on the side of the road and it didn't have a lock on it, you can't take the bike. You know it's wrong. So this is someone else's creation. So unless you are the original author, the original creator of something, don't use it without figuring out what permission and or licensing that you need to pay. And this is my favorite. People think that they go to a large domain provider like GoDaddy and they get coca-cola.me and they have the right to then just use it. You can't operate as Coca-Cola. Having a domain name is not the same thing as getting a trademark. So before you go buy up all those domain names or spend any money on branding, you should definitely make sure that you have you have the ability to eventually trademark or use that name. I've covered if I pay for it, I own it. That's not true at all. So you need to make sure you read your contracts, and if you don't like to read, then pay somebody to read for you. And finally, patents, as I mentioned, when I got my pen patent for the clicker, all it means is that I can stop other people from creating that. It doesn't mean I have the right to make pens, because I'd have to go to all the other people that own patents around the pen making and license their technology. However, the patent's value is that you can then license that clicker to everyone else who makes pens, and they cannot just make the clicker without your permission. So some of this is on our website again, and these slides are going to be on SlideShare, and both TrackLight SlideShare channel and Early Growth Financials. And we have all kinds of external resources listed on our site. We also have a free business risk quiz, which is truly free, and it goes through many of these questions and areas and gives you a bit of you get a grade, a TrackLight assessment grade, whether you're simple A, B, C, D, F. So let's hope you don't get an F. And really briefly, the financial projections piece is something where Early Growth Financials can help you, but it is something where I have seen many pitches from companies, and you will get just in so much trouble if you don't know your numbers and you're not realistic. I honestly don't know what's worse, but not knowing your numbers, standing up there with your mouth gaping open if you're pitching, you have to know your numbers. So if you're not a numbers person, definitely find someone who can help you coach with this, because it will, if you're trying to raise money and grow your company, investors will run for the hills if you don't know your numbers.
Yep.
And finally, let's hope this doesn't occur with people, is don't hide things from potential investors or as you grow. If you have pending litigation, you need to talk about it. And that's as simple as, if you're getting cease and desist letters, etc. You need to disclose it to potential investors and disclose it to your advisors, because they can generally help you. As I mentioned, if you steal somebody else's photo and use it, the fact that you try to say, oh, I didn't listen to this webinar, I have no idea. Ignorance is not a defense, and you just have to read. Like, it's either read or find somebody to read for you. And this is another resource, creativecommons.org. Great pictures there, plus explanations about what the different licenses mean. So again, these slides are available, and this is our little plug for our software platform. We've created, it's like a TurboTax experience. You don't have to know anything about intellectual property to go through this and answer all the questions. The free part is the first four sections, which is employees, contractors, and planning, which is a lot of what I just talked about now. And then if you want to use the platform, it allows you to track your IP and discover what all potential intellectual property you might have around all of your great ideas. And this is what your report looks like. You get this risk chart, and then you get a very detailed strategy report, which again, people don't love to read, which is why we built this risk assessment piece in case you don't want to read that. So That is, sorry for rushing near the end, but I didn't want to go too much over time.
No, it's great, and people will have your contact information here, so you can all see the website. I highly recommend you go check it out. It's a very useful tool, and just gives you a baseline, right? So you sort of know what you have and what you need to do and what you need to know. So I think it's a great starting point for anyone listening to this call today. Clearly, if you are interested in how to protect your company and you joined us today, this is a great the great first step to join us today, and then a great next step to go check out the site. So we're still accepting questions right now. We have one right now, and anyone, if you have anything else to ask right now while we have Mary here with us, please enter it in. In the meantime, we have a question from Peter. He's referencing back to when you were talking about protecting your trade secrets, and handshake is not good enough. He's saying he's heard that it's sort of bad form, it's unsophisticated to ask investors to sign NDAs, but what's your take on that?
Oh, definitely. So when I was listing the people that you should get to sign NDAs, which are non-disclosure agreements, that list did not include investors. It is very bad form to go ask a professional investor to sign an NDA. And the reason it is, for those who don't know, is that these investors, they don't know who else is going to pitch them. So it's not like they want to steal your idea, but they don't want to get all wrapped up in your NDA, which says they can't talk to other people in similar industries, et cetera, et cetera. As you know, if everyone on the call is running their own business, you know that it's not just the idea that is difficult. In fact, it's really I had the idea for this software that I built. I had the idea that took like 5 seconds to have the idea. It's the execution. Mm-hmm. That's where it's really hard. So you don't really, if you're going to reputable angel groups or investors, you shouldn't have to ever ask them to sign an NDA. You sign an NDA when it's a supplier. Let's say you're going out to get a prototype done. Let's say you're saying, listen, I built this really cool pen clicker. I'm going to go talk to this plastics molding company about building the pieces for this, and I'm going to outsource to them. Well, you don't just show up on their doorstep, show them everything you've built. They need to sign, and it's usually a mutual non-disclosure, which is an MNDA. You hear that expression sometimes. So that's super important. Trade secret law is different state by state, but the premise of a trade secret is that it has to be something that's valuable to your company, and then you have to take reasonable steps to protect it. So one of the very first things that you need to do is identify it as an important trade secret, and then tell your employees and contractors that it is a trade secret and they need to keep it secret. So that's what I meant there. And we have on our blog, we have a really extensive blog on TrackLight. If you just go, search in there to NDA or not to NDA, I wrote an entire article on exactly this subject. But Peter is correct. It's bad form to ask an investor, particularly a VC. One thing with angels, but never ask a VC for a NDA.
Okay, great. Good advice. Okay, I think that's it. We don't have any more questions. So folks, if you do have questions, feel free to reach out to Mary. You can use her contact information here to get to her, and also follow her at Mary Juten and at TrackLight for daily insights. And thank you all for joining us. Just a quick plug, we have one more webinar this week on Friday, and that's going to be Accounting for Startups, What Founders Should Focus On. And that's with Ryan Johnson, who's from Early Growth Financial Services. So if you want to sign up for this or any of our other upcoming webinars, or just see what we have on the calendar, just go to our website and check out our events page. And with that, thank you, Mary, so much. I think this was really useful, and we really appreciate your time, and hope you have a great day, everyone.
Okay, thank you very much. You have a great day too, Erica. Bye-bye.
Thanks. Bye-bye.